Good afternoon, everyone, and thanks for joining our September monthly policy update. If you are new here, welcome. And just another note, the independent sector hosts this monthly series as an exclusive benefit for our members, where we share the latest policy developments in Washington and their implications for the sector as a whole. Um, if I look new to you, it's because I am. I recently joined IS as Director of Advocacy and Engagement and look forward to engaging with you all as our members deeper in the coming months. In terms of today's agenda, we will begin here momentarily with the discussion on the Department of Education's recent proposed rule on the Public Service Loan Forgiveness Program, which you all have heard about. I know we've sent out some emails about it, and it's been a topic of wide discussion in the sector. The Department of Education, of course, released this rule back in mid-August, and then it opened up a 30-day comment window, which IS, along with a lot of our national partners and state partners, submitted comment letters. Um, we will be joined today by two legal experts. We are pleased to be joined by a special guest, Benjamin Leff, who is a professor of law at American University, and my colleague, Esther Jory, who recently joined IS as policy counsel. So we will hear from them momentarily about the Public Service Loan Forgiveness Program. Following that discussion, we'll be joined by Wes Cullum, who I know you all are familiar with, a good partner of ours from Washington Counsel Ernst & Young, as well as my colleague and Director of Public Policy and the previous host of this series, Wes Kershaw. Wes and Ben will give us a current look at the federal policy landscape here in Washington and what you should know today and over the coming weeks. Just a couple of housekeeping notes before we get started here. As a part of our webinar feature, all lines are muted, but we always encourage you all to engage with us. We want these webinar series to feel as engaging and as conversational as possible. So please, we invite you all to submit your comments in the comment box, submit questions in the Q&A box. I'll periodically pause and get to questions and make sure I ask them live on the series. If you don't get a chance to ask your questions while we are on the webinar today, we do invite you to email us at publicpolicy@independentsector.org. So with that, we've got a lot to cover today. I will dive right into our panel discussion and invite Ben and Esther to come on camera and join me for this discussion. And I'll kick us off with our first question here on the Public Service Loan Forgiveness Program. Esther, I'll turn it over to you first just to give us an overview of why the PSLF program matters to the sector, why this rule specifically is a pretty big deal for the sector, and why folks should get involved.
Thanks, Vanna, and thanks everyone for being here today. I'm excited to be speaking with you. So I'm going to start, as you said, with just a brief history of the Public Service Loan Forgiveness Program, and then a high-level overview of the proposed rule from the Department of Education. So the PSLF program was signed into law as a part of bipartisan legislation in 2007. And the purpose of the legislation was to incentivize borrowers to take jobs in the nonprofit sector, where they'd be doing some of the most critical and often challenging work, but those jobs often don't pay as well as for-profit jobs. And the program forgives the remaining balance on borrowers' direct loans after 120 monthly payments made under an accepted repayment plan while the borrower is working full-time for a qualifying employer. And under the statute, a qualifying employer includes a 501c3 nonprofit organization. So in August of this year, the Department of Education, which promulgates regulations to implement this statute, proposed a new regulation that would revise the definition of qualifying employer to exclude specific organizations that, quote, engage in activities that have a substantial illegal purpose. And in the proposed rule, they define substantial illegal purpose as in a number of ways, and I'm going to use the language from the proposed rule. It includes aiding or abetting violations of federal immigration laws or illegal discrimination, supporting terrorism, engaging in chemical or surgical castration or mutilation of children in violation of federal or state law, or engaging in a pattern of violating state laws such as trespassing, disorderly conduct, public nuisance, vandalism, or obstruction of highways. So the proposed rule sets out two situations in which the secretary can disqualify an employer for having engaged in activities that have a substantial legal purpose. So the first is where the employer fails to self-certify that it did not participate in activities that have a substantial legal purpose. And the second circumstance is where the secretary nonetheless determines that the employer did engage in activities that have a substantial legal purpose. If you think this sounds a little bit circular, I agree with you. The proposed regulation also would set out a standard for the secretary to make this determination. It uses the preponderance of the evidence standard, which basically just means that the evidence makes it more likely true than not true that in this case, an employer has engaged in certain activity. The proposed regulation would include some evidence that the secretary would deem conclusive, which is along the lines of a final judgment of a state or federal court, a guilty plea or no contest plea, or a settlement in court that includes admission. But the secretary can make this determination without any kind of court finding or judicial process. It does provide for notice and an opportunity for the employer to respond before a final determination, although it doesn't give a lot of detail as to what that would look like. If an employer is disqualified, there are two ways that they would be able to regain eligibility. The first is that 10 years after the final disqualification, the organization could certify that it is no longer engaged in activities that have a substantial illegal purpose. The second method would be that if you wanted to regain your eligibility in less than 10 years, the secretary could approve a corrective action plan signed by the employer. Now, the proposed rule is explicit in saying that there is no available mechanism for the borrower to request reconsideration of their employer's disqualification. The employer, as I mentioned, does have an opportunity to respond before a final determination is made, but the proposed rule does not lay out any specific mechanism to challenge a final determination after it's been made. So that's just sort of a high-level overview of what the proposed rule would do. And I think it's pretty obvious this would have a big impact on the sector. As I mentioned, the whole purpose of the Public Service Loan Forgiveness Program is to incentivize people to go and work for nonprofits. In Congress's view, the work and the public good of the work that these nonprofits are doing is really important. And so they wanted to give nonprofits a tool to encourage people to come and work in exchange for the understanding that after 10 years, they would have their remaining student loans forgiven. Recent research by Independent Sector and United for Alice shows that in 2022, 22% of nonprofit workers lived in households with income below what's known as the Alice threshold of financial survival, which is basically the cost of household essentials in a person's county of residence. But these people may nevertheless earn more than the federal poverty limit and therefore not qualify for traditional public assistance. So for these people especially, the PSLF program can be a really necessary part of how they make decisions about employment. A 2025 survey from Mission Square Research Institute found that 56% of public sector employees and 62% of private sector employees make job decisions based on their student loan debt levels. So clearly, creating uncertainty in the Public Service Loan Forgiveness Program is going to negatively impact nonprofits' ability to attract and retain workers. And in addition to the policy implications of the proposed rule, there are also a number of legal and procedural issues with the proposed rule. And Independent Sector identified some of them in its comment, which I'll talk about really briefly. Professor Leff will identify others. So the first is that, in our view, the Department of Education simply doesn't have the statutory authority to exclude specific 501c3 organizations or a subset of 501c3 organizations. The statute says that the secretary shall forgive the remaining balance for a borrower who is and has been employed in a public service job while making qualifying payments. The statute includes a list of the types of employment that count as a public service job, and it includes, quote, an organization that is described in Section 501c3 of the Internal Revenue Code. And so the Department of Education simply can't just ignore that part of the statute. Secondly, and Professor Leff, I think we'll talk about this further, the IRS already has a process to strip tax-exempt status from a 501c3 organization that engages in illegal activity. And an implication of that is that they would also then no longer be eligible as an employer under the PSLF program. And so this proposed rule is duplicative and also confusing in that it claims to mirror this process that the IRS has, but doesn't in fact directly mirror it. And so it is both unnecessary and confusing. In addition to that confusion, the proposed rule will also create confusion because it relies upon a patchwork of state and federal laws in determining what is illegal activity. And so what may be illegal for one organization in one state might not be illegal for another organization in another state. Moreover, it requires the Department of Education to engage in fact-finding and to make legal conclusions which are outside of its area of expertise, such as federal immigration law. Finally, the proposed rule would place significant risk on borrowers while removing their due process rights. So again, here, this program is essentially a bargain between the federal government and borrowers, where the government says, you go work in these areas and for these employers that have what we view as a public good. And in exchange, after 10 years, we will forgive the remainder of your debt. But under the proposed rule, the borrowers themselves would have no opportunity to challenge their employer's disqualification. And moreover, there really isn't meaningful opportunity for employers to challenge it either. And so the result, I think, is pretty predictable. If this were to be adopted, we would end up with vague rules, which will lead employers to hold back from engaging in legal, mission-driven work. And borrowers will be reluctant to work for nonprofits because of uncertainty about whether their loans will be forgiven. And so, we highlighted these concerns in our comment and urged the Department of Education not to adopt the proposed rules. And Professor Leff is going to talk about some other concerns.
Esther, thank you so much for that introduction. I was just going to call on you, Professor Leff, to pick up from there to talk about some of the comments that you all submitted from the academia side of things. But I also want to remind folks to please drop questions in the questions box. I know that this is a really kind of a tricky topic that we're discussing, but a very important one to the sector. So I do want to invite folks to drop your questions. But Professor Leff, please.
Thank you. Thank you so much for having me. I'm so happy to be here. Again, my name is Benjamin Leff, and I teach tax law and nonprofit law at American University's Washington College of Law. And I was a co-author on a comment letter from professors who teach tax exemption law. And so I just want to spend a minute to kind of give a little bit of background on this substantive doctrine that the rule is attempting to kind of import into the public service loan forgiveness program. And it's generally called the illegality and fundamental public policy doctrine. I mean, formally, those might be two separate things, but we're just going to talk about them together right now because the proposed rule doesn't distinguish. So in a very fundamental way, the illegality and fundamental public policy rule is right at the heart of what is important about the independent sector and about the laws governing the independent sector, because it is so almost all of there's sort of no statutory authority for this rule. The whole rule comes from effectively a single Supreme Court case, Bob Jones University versus the United States, which was decided in 1983. So people may be horrified to be reminded that that is 42 years ago. And really if you were a tax exemption professor, you spend a shocking amount of your time thinking about, worrying about, memorizing this case. And why is that? It's because in the case, the Supreme Court held that a organization, a charity that otherwise qualified for tax exempt status. In other words, these were two universities, so they met the charitable purpose of being educational. But the two universities at issue discriminated on the basis of race among their student body, one in admissions and the other in a fundamentally racially discriminatory policy. So, and the Supreme Court held that an organization that violated a fundamental public policy or engaged in or in which their purpose was fundamentally connected to illegality, couldn't qualify as a charity because it didn't advance the public service, the public interest. But in that opinion, the Supreme Court is very careful, and there's a majority opinion and a concurrence and a dissent. And in those opinions, the Supreme Court is very, very careful and very conscious of the fact that this principle, the idea that the federal government can decide that an organization is not supporting the public interest and therefore deny it tax-exempt status, is a very significant threat to the independent sector, and therefore has to be cabined or constrained very vigorously. And the Supreme Court opinion itself has all sorts of mechanisms to attempt to describe how this doctrine should not kind of run away. And then for the last 43 years, the IRS has been extremely cautious about applying this doctrine and have only applied it, have very rarely moved beyond the kind of origin circumstances. So that was kind of explaining that, and therefore why both substantively and procedurally, this proposed rule is a distortion, a very dangerous distortion of the fundamental public policy doctrine, because what the rule does is, first, it substantively characterizes the rule in a way that does not maintain the restrictions that exist in the law currently. It dramatically expands the ability of the government to employ this doctrine as a sword rather than a shield. And then procedurally, by moving the enforcers out of the IRS and into the Department of Education and creating a redundancy, which Esther described, in other words, already under current law, if the IRS determines that an organization is engaged, is violating the fundamental public policy or illegality doctrine, the IRS would revoke their tax exempt status and they would automatically cease to be a qualified employer. Here, what the rule purports to do is to say, we don't care what the rest of the federal government thinks, and we don't care about whatever any criminal enforcement agency thinks. We don't care if the Department of Justice thinks that the behavior is illegal. We don't care if the IRS thinks the behavior is illegal. The Department of Education is going to make its own independent determination over illegality, and its enforcement will be to prevent students from participating in the public service loan forgiveness program if the employer has been determined by the Department of Education to violate the rule. So the letter effectively tries to describe why substantively and procedurally that's a bad idea. And I can say as much more about that as is possible. For our purposes right now, I'll just say substantively, the rule as described in the proposed rule is much more aggressive in a variety of ways. It explicitly adds aiding and abetting as a way of violating the rule. It seems to, it keeps talking about a fundamentally illegal or a act, but the rule talks about illegal acts that are fundamental to the organization's tax-exempt purpose. So an organization that engages in illegal activity does not violate the illegality doctrine. An organization whose purpose cannot be enacted except for its engagement in the illegal activity. That may be a slight overstatement, by the way, but an organization who the illegal activity is very fundamentally connected to the organization, what the organization purports to do to advance its tax-exempt purpose. So a great example of this is the IRS has taken the position that 501c3 organizations that actually sell cannabis as their activity in order to promote health fail under the illegality doctrine, because even if they're legal at the state level, at the federal level, selling cannabis is a federal crime, and therefore you can't be a charity that promotes health by engaging in an illegal activity. But that's because that illegal activity is per se illegal, and the organization sort of cannot engage in its activity unless it engages in that. Any organization that advocates for the use of cannabis or in other ways facilitates is a perfectly valid, if it meets all the other restrictions, a perfectly valid charity. So it misunderstands the fundamentality basis, and then there's no clear statement about criminal versus civil applications of the rule. And in the examples, it gives examples of kind of shockingly contested interpretations of illegality. So one of its prime examples has to do with gender affirming care, and it describes gender affirming care as if it is clear that the performance of gender affirming care under all circumstances violates certain anti-discrimination laws. And that's just they've picked an example that is especially provocative in terms of thinking about what is clearly illegal, what does it mean to be engaged in a fundamental illegal activity. So they've the rule suggests a very aggressive application of this rule. And then procedurally, which in a lot of ways, maybe even more importantly, procedurally, by moving the application of this rule out of the IRS and into the Department of Education, without the Department of Education having the history, knowledge, or express procedural constraints that the IRS has, there's the opportunity for it to be very much more easily weaponized by an administration against the sector. And it should be clear, the rule really signals that it is intended to be used by a Republican regime, but the rule is equally applicable on both sides. In other words, once you have created a very easily weaponizable rule against the independent sector, then sort of it flips whenever you flip who the administration is. So and some of those procedural protections, the IRS, people are very scared of the IRS being weaponized by an administration, but for the last more than 50 years, both Congress and the Treasury Department have constructed a series of checks on the IRS's or supports for the IRS's independence that make it just structurally more difficult, including the tax-exempt status. There's a special quick to court procedure to get a declaratory judgment if the IRS revokes your tax-exempt status. It's very well understood kind of how you do that. And here, as Esther pointed out, the legal mechanism to get some kind of review of a Department of Education determination about illegality in this context is much more ambiguous and much less operational. Is that? I'll maybe stop there and
No, that answered, and you were actually sort of leading me into my next question. I'm going to skip around a bit and continue with you, Professor Lev. Just thinking about, of course, the comment period ended last week, and just thinking about where we are now and what folks on the call should be thinking about in terms of this rule. I know that it is a proposed rule right now, but just a sense of the process, where we are and what would be good for people to be thinking about for the future.
Sure. Thanks. The comment period is closed. My understanding is there were 11,000 comments on this rule. So what the Department of Education's job now is to read all of those comments and then think about whether to implement the rule. And there's a variety of things they can do. They can implement the rule as it's written. They can change the rule. They could withdraw the rule, or they could do nothing and let the rule sit there kind of as proposed but not adopted. It's conceivable that in all of those scenarios, except withdrawing the rule, that even without any enforcement action, the rule may have some chilling effect on the sector. That could happen just by kind of stating the rule. One thing that people can do is kind of think about and communicate with each other about their stance on how to respond, even just behaviorally, not even in a legal sense. Once the rule is adopted, then even without any enforcement, there could be legal challenges to the rule on its face. And I'm not an administrative law expert, so I'm going to not try and say anything about the scope of those legal challenges. And as I'm sure everybody is aware, administrative law is undergoing tremendous changes right now. And so the things that I probably think are true from a few years ago are probably not true anymore. So there's the possibility of there being legal challenges on the face of the rule for exactly what Esther said, for the rule exceeding the statutory authority that the Department of Education has been granted to interpret and implement the public service loan forgiveness. And I entirely agree that this rule, in my opinion, clearly exceeds the statutory authority granted. And then, of course, once the rule was enforced, once the Department of Education decided to disqualify an employer, then there would be legal action from the employer. And there's some confusion about kind of what exactly would be the legal action if a student who lost their loan forgiveness through this. I think it's very plausible that a student would also have standing for a lawsuit, though the rule purports to not grant that kind of standing to a student.
And you keep leading me on to my next questions in terms of the rule not sort of spelling that out. And Esther, I'm going to turn it back to you, and Professor Leff, feel free to chime in here if you have thoughts. But we've talked about before, and you all alluded to it as you talked about our comments, some of the more problematic, just sort of unknowns within the rules. We talked about there's a lot of things that are missing within the rules, and you talk about the ability for people to be engaged or to be accused of aiding and abetting, all of these things that we find problematic. Talk a little bit more about some of those unknowns. And Esther, I'll turn it over to you.
Sure, thanks. So as you sort of alluded to, there are, I think, many unknowns in this proposed rule as drafted. So I'll just talk about some of the ones that stand out to me. The first is that, the proposed rule says that there are two circumstances in which the Secretary of Education can disqualify an employer. The first is this failure to self-certify. As part of the public service loan forgiveness process, a borrower has to submit a form to the Department of Education, and they have to have their employer certify certain things. And so as part of the proposed rule, they would add language to that form where the employer would have to say, we have not engaged in any of these activities. But the other way is just that despite that, the secretary could just make this determination on their own. And it's unclear what would trigger that. So would people file complaints? Would the Department of Education be able to initiate investigations on their own? The proposed rule doesn't say anything about that. Another unknown is that the proposed rule says that the determination would be based on the preponderance of the evidence, which again just means that the evidence shows that it's more likely true than not. But it doesn't say anything about what that evidence is. Is this evidence in sort of a courtroom evidentiary standard way? Is this just another word for information? Could the Department of Education, for example, use something that's in a newspaper article? Would they have subpoena power? None of this is laid out in the proposed rule. And then sort of following on to that, the proposed rule says that an employer is going to get notice and an opportunity to respond before a final determination. But again, it doesn't say what that would look like, when they would get that notice. One big question that I have is, would the employer get notice of all the information or evidence that the department is considering in making its determination? And would they have the opportunity to respond to all of that evidence? Or are they just going to get, a letter that says, we're investigating you for having violated or, engaged in activity that has a substantially illegal purpose. Do you have anything to say about it? And, so all of these things, I think, really add to the confusion and the uncertainty that is going to result in employers censoring themselves or not engaging in lawful mission-driven activity, because it's very difficult under the proposed rule, and again, it hasn't yet been adopted, but it would be very difficult to sort of assess risk, or to know, not only do you not know if your own activity is within the scope of what's being addressed here, but even if it's not, how would you go about showing that? And so I think all of these things, as I said, and as Professor Leff said, I don't think that this rule should be adopted at all. We already have a process. But even if it were, I think that all of these things would need to be spelled out in order to provide notice to employers about what is expected of them.
Professor Leff, anything to add there? I feel like Esther covered a lot of the
Yeah.
unknowns, but just wanted to open.
No, I agree with everything she said.
Great. Well, I don't have any other questions for our panelists. I wanted to turn it over to the audience to see if you all had any questions, comments about the rule itself, some of the problems within the rules, the unknowns, or anything about the process moving forward. I am not seeing any on my end. So I will begin to wrap us up. Professor Leff, thanks so much for lending your expertise to this discussion. To our members, thank you all for joining. We've got a second piece of this session, so stay put for that. But wanted to thank Professor Leff for his time and expertise, and we will keep you all posted as things continue to progress on this front. We will certainly, send out notices to our members as things progress, and as the potential for this rule to be adopted comes about, we will keep you all abreast. So thanks again, Professor Leff, and we appreciate the time. And at this time, I will turn things over to my colleague Ben, as well as Wes Coulomb from Washington Council Ernst Young, for some key legislative updates, including the potential for a government shutdown, which I know is on the minds of a lot of people these days. So Wes, I'll turn it over to you just to give us a lay of the land on Capitol Hill right now.
Yeah, thanks, Vanna. Appreciate being with you this afternoon. So, September often is budget month, right? We're kind of up against the end of the fiscal year. And so September is dominated by conversations and negotiations on the end of the year appropriations process, and trying to get us beyond October 1st in the spending debates. So we're 5 days away from the end of the fiscal year. And it looks like, as of now, it looks like we're going towards a potential shutdown of the federal government on October 1st. Last Friday, the House passed a CR to extend government funding until November 21st, and that passed the House. The Senate had competing votes on their resolutions. One was the House passed resolution, which failed to get 60 votes, because 60 votes required the Senate to pass the CR. And a competing Democratic proposal to extend government funding, but also include various proposals to deal with healthcare. One thing the Democrats have been pushing for is, at the end of this calendar year, the premium tax credits that were enacted in 2010 as part of the ACA were expanded in 2021 to make them more generous for individuals who buy insurance through the exchanges and through the ACA marketplace. Those higher subsidies expire at the end of this year, so the tax credits would be reduced come January 1st. And so Democrats are wanting to extend those as well as other changes in the healthcare space to undo some of the Medicaid changes that were part of the big bill that Republicans passed in July. And so that resolution in the Senate to extend government funding as well as do some of those healthcare fixes also failed. And so Congress left town for this week to be on recess without completing any sort of extension or CR to extend the federal government's funding. They do come back next Monday, at least the Senate does. We'll see if the House comes back next week as planned, or there's some comments they might not come back until after October 1st. And so it looks like, given there's no resolution on a CR, we might be heading towards a government funding shutdown on October 1st. There also was efforts to have a meeting between the Democrat leaders, Leader Schumer and Leader Jeffries, to meet with President Trump today. That meeting was canceled and did not occur. So there's actually, no negotiations taking place between the two sides on trying to get a resolution done by October 1st. So we'll see how the next 5 days progress. But as of now, looks like no breakthrough or compromise is on the table or being discussed, or certainly not close to being reached. President Trump has also been saying through his OMB director that if there is a shutdown, they will be very aggressive in laying off additional federal workers. As you know, in the past, traditionally, we've had shutdowns. We've had several shutdowns in past years, some for a few days, some for several weeks. Congress has always retroactively reinstated those employees and given them back pay, which is the tradition when we have government shutdowns. And so we'll see how that plays out going forward. I think that would be the standard they would apply here, but President Trump and the Trump administration has been pretty aggressive in saying if we shut down, we're going to try to extend and do more layoffs of federal programs and federal workers as well. So, they've only passed three appropriations bills, separate appropriations bills in the House, and three different ones in the Senate, I think, two or three. And so they're kind of far apart on even reaching agreement on some of the individual appropriations bills as part of this process. So a couple of things could happen. We could have a government shutdown next week. Number two, they could reach some sort of agreement to just temporarily avoid shutdown by doing a short-term extension for a couple of weeks, and give them some more time to negotiate. Or we could have a shutdown, and then after a couple of weeks, they shut down. They come to some sort of compromise on some of these outstanding issues that they need to deal with. So really unclear as to what the next steps are and how they reach agreement on this issue. You also kind of think about what's on the end of the year conversation. I think that what happens in this conversation about the budget really determines what happens next in the end of the year conversation. In past years, we've had CRs that would kick the can into December, and then we had negotiation to try to pass either in small batches or in one omnibus appropriations bill, all the appropriations bills at the end of the year. We've also seen years where they kept kicking the can on the road. They pushed the CR into February or March the following year, and then where they finally ended up going backwards and finishing up the appropriations process in the first quarter of the next calendar year. So lots of options for this to kind of play out, how it goes the next couple of weeks and months. There are a few things in the tax space that are trying to get finalized and finished. Some expiring provisions. Work opportunity tax credit is one that's on the list of bipartisan ideas to get included. But obviously, for that to get done, there'd have to be some sort of bigger package with a tax title that originates in the House in order to be able to move that WOTC extension with that package together with a bigger bill. So we're kind of waiting to see how these negotiations play out to see what happens next on the legislation front. Happy to kind of stop there and think about what's next.
Yeah, thank you, Wes. We have a couple questions. One, you started to touch on when you talk about the long-term impact, but I want to ask it anyway, just for your thoughts. What does a long-term impact look like in the event of a shutdown? Thinking about the recent OMB memo, how much of that feels rhetorical to pressure a shutdown resolution?
Yeah, no question. This is part of a negotiation. Both sides are trying to gain leverage and try to get the other side to blink. So I think there is some element of that. trying to, from the Trump administration, trying to make this as painful as possible. The Democrats will want to concede and agree to a short-term extension or extension without demanding their healthcare fixes. On the things that the Democrats are asking for, obviously the Medicaid changes that were part of the bigger bill that passed, reconciliation bill that passed earlier this year, I think are not likely to be supported or accomplished. But on the premium tax credits that expire in this year, you have a handful of Republicans in the House who have sponsored legislation to extend those expanded tax credits beyond the end of this year. So there is bipartisan support for that idea to address that issue at some point. So that to me is probably the key issue, sticking point. They could probably work out some sort of agreement between them on that issue as part of some sort of compromise to extend their federal government funding. Long term, we'll have to see how it plays out. What happens? Obviously, the administration has been very aggressive in funding issues. Rescissions have been something they've been pushing for. So that will continue going forward. We'll see how the appropriators respond. Right, appropriators appropriate the money, and they expect the government or expect the administration to spend that money as they directed. So we'll see how that negotiation plays out, impacts the spending going forward.
Thank you, Wes. And Ben, I saw you unmuted. I was actually going to turn it over to you. I know there's a question about the executive order, and I wanted to hold off. I know we'll address that a little bit later. So, Ben.
Yeah, thanks, Vanna. And it's really fun to be with you all in this role. Psyched to have Vanna and Esther on the team. We're gonna try to keep these, I think, to one Ben per panel. So we're breaking up our Bens here as well. I think on the shutdown piece, it's very clear that it's a threat and it's a negotiating posture, as Wes said. I would keep in mind, right? I think the first rule of any negotiation is not to make threats you're not prepared to back up, right? Right. That's true of parenting threats as well, I think. President Trump has a lot of credibility on this. He has tried to do much of this already outside of a shutdown. So, Chuck Schumer's warnings from a few months ago that a shutdown would give the president the chance to do a lot of things that would be painful for the workforce and for programs that the nonprofit sector cares about, certainly seems to be prescient. So we'll see. I mean, from a nonprofit sector perspective, shutdowns, right? They hurt the deficit. They hurt the programs that our people use to serve people, and they increase demand, especially if a bunch of federal workers are laid off and in need of services. So shutdown would be a big a really bad thing in many ways. I want to also draw us back to one thing that Wes noted about assuming we get through the next few weeks and the possibility of year-end legislation. Independent sector and the nonprofit sector have a wide range of tax priorities that we would love to see in a year-end bill. We would love to see legislation repealing some of the bad stuff that happened in the reconciliation bill happen this year. We don't really predict that that's going to happen, but we are going to continue talking to legislators on the Hill about the damage that the new 1% corporate floor is predicted to do to giving, the damage that the limit on the value of itemized deductions for high income taxpayers who tend to be some of the most generous donors, negative impacts of that. So we're going to continue talking to legislators about that. One more concrete opportunity that Wes noted is the work opportunity tax credit, right? This is a tax credit for hiring people who face barriers to employment, whether that's because they have some record in the justice system, or they face a disability, or they're on public benefits right now. That tax credit is quite mission aligned for our sector, right? It's an incentive for hiring a lot of the people who receive charitable services. And so there's value in it the way it currently exists. But that tax credit is meant to incentivize employers to hire these populations. And unfortunately, that incentive is a credit against the income tax. Now, right, all of you who've been with us in previous months know that nonprofits pay a lot of payroll taxes, but they don't pay income taxes usually. And so we have an opportunity to ask Congress, to tell Congress that if they're going to extend this credit, and it's not a given that they will, right? If they're going to extend this credit, that they ought to make it easier for nonprofits to claim it by allowing them to claim it against their payroll taxes. And if this sounds like a complicated spiel for you to repeat to your legislator next week, you don't have to. So there's a sign-on letter right now for national nonprofit organizations only to tell legislators to include nonprofits in all categories of the work opportunity tax credit. And again, this is ripe because it is due to expire at the end of the year. Bipartisan provision. Not seeing further questions about that, I do want to circle back to this question about an executive order targeting philanthropy or our sector, and pull us back to kind of where that conversation starts, which is with the horrible assassination of a political figure in our country recently. So we've seen increased scrutiny of the nonprofit sector in light of the Charlie Kirk assassination. We have seen many nonprofit organizations, including independent sector, unequivocally condemn political violence and state that political developments and political violence should not be used as an excuse to quash civil society and to pursue political agendas against organizations that one might perceive as not aligned with them. So we've heard senior officials in the Trump administration argue, largely without evidence, that left-leaning nonprofit organizations are responsible for both this particular act and sort of broader trends in political violence. And earlier this week, the administration issued an action formally designating Antifa as a domestic terrorist organization. Important to note that Antifa is not a registered 501c3 or C4. And so the practical implications of this particular action are limited, but we've also seen reporting in the press that the administration has a list of left-leaning organizations that they view as not in line with their goals, and that they're considering things like trying to revoke the tax-exempt status or designating these organizations as terrorist groups. This is not the first time we have seen speculation that the administration or some within it might try to do something like this. It is no less concerning now than it was back around Earth Day. We heard rumors that there could be an additional executive order coming out as soon as today, targeting some groups, but we've not seen any further evidence of that. And unless Wes has breaking intel for us, I don't think we have any further rumors or speculation about what that might be or when that might come.
Yeah, nothing to announce, or we've seen anything, but there's been lots of rumors about timing of something coming out. I think that on the lines of giving DOJ, Homeland Security, some more authority to go after organizations. Obviously, the statute prohibits the president and the White House from directing the IRS to audit certain taxpayers, but certainly the IRS itself can initiate audits. So that's a possibility there. So we're kind of waiting and seeing, but definitely lots of conversations, I think, and expecting something to come out administration along these lines at some point. Just not sure what it will include.
So, Vanna, before we pause for questions again, I just want to add an update on one other issue, and it might be surprising, but it's actually a positive one. So in late August, we collectively as a sector learned that there was a threat to the combined federal campaign, which is the workforce giving campaign for the federal workforce. The Office of Personnel Management had put a pause on it and signaled that they may not proceed with this year's campaign due to launch on October 1st. In part as a result of a sign-on letter that I know we circulated to many of you all and that many nonprofit organizations joined, I think over 400. There was an announcement on September 10th that the combined federal campaign would continue and that it would, begin on October 1st as previously scheduled. I think the federal government shutdown certainly throws some more question marks into that. But I don't think that the long-term future of the combined federal campaign is secured, but this is clearly an instance where somebody was trying to get away with something and the sector spoke up, and we at the very least live to fight another day for the combined federal campaign. So let's keep that up. Thanks.
Great ending, Ben, on let's keep that up. And we'll keep you all posted as we're still in those conversations with the coalition around the CFC. I know someone in the chat asked about the WOTC letter and if it's still for national organizations only. And I do want to echo Ben and say, yes, it is. But state and local organizations, you will have an opportunity to engage on that once the signed letter is submitted to members of Congress and the administration. We invite you all to share the letter itself with your members of Congress. So while you can't sign on now, please do share the letter with your members later. I want to circle way back before we open up for questions. And while I'm asking you all this, folks in the audience, please feel free to put more questions in the chat. But Ben and Wes, I'm always thinking about the members that we have that are not quite well versed on DC and the who's who in Congress. When we talk about the shutdown, just because that is the thing that is most pressing right now, who are some of those major players, some of those major influencers right now who are either holding out or just really influencing the decision to move forward on a shutdown or not?
Well, it's going to be a negotiation with the leadership, the speaker, Leader Jeffries, Leader Thune, and Leader Schumer. On the Senate side, and obviously the president and the White House staff will be in negotiations on figuring out some sort of solution. Whatever gets done has to get the votes in both the House and the Senate, right? And the House, as we saw, can pass something on a partisan basis, but the Senate must pass something with Democrat votes. It cannot pass it simple majority votes. So it needs to be a negotiated compromise between Democrats and Republicans on some sort of extension, either short term, longer term, or some sort of policy negotiated solution on some of these issues that they're trying to resolve. So at the end of the day, it's really kind of going to take place at the top levels, the White House, the leadership, until they get to a solution in the next couple of weeks.
Perfect. Thank you for that. And I'm going to pause to see if folks have questions. Any final questions about anything that we've discussed here? Is there a sense of which departments will be affected if the RIF happens, the reduction of force happens? The OMB memo is very broad and vague.
Yeah, no, there's not any insights into what would be the effect of that and where they would be targeted and how many or who would be impacted. So kind of TBD on that, and see if the administration actually follows through with that, or was it more of just a threat to get Democrats to come to the table. Obviously we've seen for this past year where there've been a lot of buyouts, RIFs, layoffs, and so I'd imagine it's going to continue with or without the shutdown to some degree. But we don't have details as to what where they would target those actions.
I mean, this may not be news to the questioner, right, who's read the memo, but right, some data points are right. We see agencies and programs that are not aligned with President Trump's agenda. They're right. So, or programs that did not receive extra funding as part of the reconciliation bill. We've seen speculation that, RIFs would not impact Social Security and Medicare and veterans and the Department of War. So those are some intel pieces. Lots of uncertainty.
Any other questions before I get into some final housekeeping items and wrap us up this afternoon? All right, seeing none, and I'll check again momentarily, but I did want to leave you all with some final reminders as we sign off here. The first being that we will not hold an October monthly policy update. Instead, we invite you to our bigger policy update, which will be our National Summit, our Independent Sector National Summit, which will take place October 27th through the 29th and down in Atlanta. So we hope that all of you will join us down for our summit. In addition to our summit, we hope that you all will also join us for our pre-conference session, which is specifically intended for public policy professionals. We'll have lots of great sessions throughout the day. You all will see Ben, myself, and some others in person for just a great morning and afternoon of programming as it relates to public policy. We've dropped the links to both of those in the chat, so if you're not already registered, we certainly encourage you to do so. And then I also want to encourage you all to take both of the actions that we've shared in the chat box, and not only take them yourselves, but share them out with your network, both the Small Nonprofit Retirement Security Act, as well as the WOTC sign-on letter that we're circulating. So with that, I am going to check the questions box one last time to make sure, and just as suspected, I figured we'd have a last one. I don't know who wants to take this one, but have you all seen any individual nonprofits being targeted and their employees individually?
I mean, to the extent this is a question about, right, the White House actions, the two nonprofits that we've seen named most prominently by the vice president are Open Society and Ford Foundation. And there's a claim of a connection to some some article that was written, and that the connection is not a real connection. So those are two organizations that certainly have been named publicly, and that the that the vice president has named before. So other than that, we're not seeing a whole lot specifically.
Thank you, Ben. So with that, I will wrap us up this afternoon. Thank you all for joining us. We've also dropped a link in the chat for you all to take our short survey about today's webinar. Please fill that out. Give us feedback about not only today, but future webinars like this. As I mentioned at the top of the webinar, I will be replacing Ben as your host for these monthly webinars. So I would love to get any feedback that you have on format or just content or anything that may be helpful for me. So with that, you all have a great rest of your afternoon, and we will see you at the summit next month and then our next monthly policy update in November. Have a great afternoon.